let's get into it. I won't keep you guessing. This guy's a treat.
Okay, they can see. Can they hear you?
I don't know.
Say something. Ask them.
Mr. King, can you hear me?
Yes, sir.
Okay. I just want to make sure. There you go.
Good afternoon.
Good afternoon, Your Honor.
Mr. Requena, can you hear me okay?
Yeah.
Props to him on the beard, though. I mean, good job, dude.
Okay. All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Case is entitled State of Kansas versus Adrian Michael Requena. Case number 21 CR 180. Attorney Zachary King appears, and you're representing the 13th Judicial District, Mr. King, is that correct?
That's correct, Your Honor.
All right, and Mr. Requena, the defendant in the case, appears by Zoom pro se. This is a post-sentencing matter in which Mr. Requena has filed a request for hearing regarding a garnishment for the collection of court costs and fees and so forth. Are there any other matters currently before the court that you're aware of, Mr. Requena?
No, and I was not notified of this hearing until just now. And I don't understand how Butler County is being represented and I'm not being represented, since this is a sentencing matter rather than a civil.
Well, it's a post-sentencing garnishment.
I understand that, Your Honor, but if the state's being represented by counsel, defendant should also be represented by counsel.
How exactly would it work if the state wasn't represented by counsel? Like, are you going to cross-examine a map? I'm confused on that.
And
Well, the state's not being represented. Mr. King represents the 13th Judicial District, who's collecting the court costs and fees on your case.
Right, Butler County.
Butler County is part of the 13th Judicial District, correct?
Yeah. But what I'm saying is Butler County is being represented, but I'm not being represented. And he, in his, in the matter of a garnishment, it's a civil thing. So, I mean, at this point, I would like to do a counterclaim on Butler and Associates, because Butler County never notified me that I had a fine to pay or anything. And at sentencing, the court never said that I had to pay it while I was incarcerated. So I'm saying
you were ordered, you're not entitled to counsel for a civil matter, Mr. Requena. So you were ordered to pay court costs, and I don't recall specifically what else at the time of sentencing, and that's what Butler and Associates is attempting to collect.
Right. At sentencing, which I remember sentencing that you gave me, you never specified that I had to pay this while I was in prison. And according to previous statutes, that an individual doesn't have to go to prison and pay court costs and restitution at the same time. Because
well, you weren't ordered to pay any restitution, Mr. Requena.
Well, then I'd still want to do my counterclaim, because Butler County, like I said, the 13th Judicial District never notified me and then handed this over to a collection agency without giving me an opportunity to pay it. So I want to do a counterclaim now under 6213 in order to sue you, the 13th Judicial District, for allowing a collection agency to collect it without notifying me first. I mean, that's what-
You can file whatever claims you wish, Mr. Requena, but you're the one who filed this request objecting to the garnishment, and that's what we're taking up today.
Right, I am objecting to the garnishment.
All right, I'll go ahead and allow you your chance to argue your motion at this time, Mr. Requena.
Well, I can't argue it because, like I said, I wasn't even notified of this until just now about this hearing, so I'm not even prepared. I don't have no paper, no pen, no books in front of me, no, you know what I mean? I don't have nothing in front of me that is helping me with this motion that I'm trying to file. So
You're not trying to file it. You already filed it. And this is your court date.
I would like a continuance so that way I can file something in the court and then I'll be more prepared.
Mr. King, your position.
Your Honor, I show an electronically filed notice, January 31st, 2024, setting the matter for March 1st at 1:15 p.m. by Zoom, and it shows notice went to Adrian Requena, care of Jennifer Dame, correctional counselor at Hutch Correctional Facility. So I believe Mr. Requena has had ample time.
If I may, Your Honor, the
Go ahead.
facility has not only the sort team go through the mail when it comes to legal mail. And if this is true, then I would have received a piece of paper because we don't get the mail. The mail is copied and then given to us. And we have to sign a piece of paper showing that we received that. And I can prove to you that I never received any mail from Mr. King.
It didn't come from me. It came from the court, and I'm holding a copy of it here, and I'm sure the judge can find it electronically in his record on January 31st, 2024.
Well, I'm not saying that didn't happen. What I'm saying is I never received nothing. And I can prove that through KDOC system because they make us sign when we receive legal mail. And I can prove that I never received.
Mr. Requena, you are the one who filed the action that brings us here today. You cited State versus Bowers.
That is true
in
because
your request for hearing.
I'm sorry, Your Honor, but that is true. Mr. King in his office sent me a piece of paper. I filled it out and sent it in saying, yes, I would like a hearing. But between the time that I filed that to now, I have never received anything from the court or anybody saying that I was going to have a hearing. Otherwise, I would have prepared for that.
Your Honor, I believe 2 points will resolve this case, whether he prepares further or not. The first point is this is a non-wage garnishment to the Department of Corrections, meaning it was filed and they answered what was in the account at that time. They responded that there were no funds on January 16th, and then defendant filed his objection January 25th. So the garnishment we are here on today is moot. No funds were withheld, so even if his arguments held merit, it's still without any action being taken because no funds were withheld from him. So there is no need for further hearing on this case, even if he were correct in the law. But he's not correct in the law. The law he is citing is Bowers. Bowers deals with restitution. As the courts advised, he wasn't ordered to pay restitution, so Bowers wouldn't apply anyway. But even if Bowers applied to this case, KSA 216604 was amended in June 20th, which overrode the Bowers decision. So even if Bowers did apply, it's no longer good law to cite to in 2024. KSA 216604 would be controlling. And that states that if an order of restitution was entered and was not ordered due and owing immediately, he had until December 31st of 2020 to seek the court's determination on that, or it becomes due and owing immediately and can be turned over. But again, that's only dealing with restitution and there's no restitution. So that's not applicable to this case, regardless of the statutory amendment. So I don't see any reason for the court to continue this matter and drag it out further when no money was withheld and he's citing badly.
So no
If I
money was withheld and no money will be withheld in the future?
Oh, I'm not promising that. I'm just saying on this garnishment, no money was withheld. I will definitely try and collect it going forward. And at that point, if he wants to raise an argument and cite real law, we can deal with it then.
If I may, Your Honor.
Go ahead, Mr. Queen.
Fair, this is under federal case law and federal statute, but fair debt practices, not only the county or the state has to follow certain guidelines along with the collector. And nobody's followed those so far. So, I mean, you're in violation of federal law from the beginning, Mr. King.
No,
And
sir. Because
I
you
can
consume-
I know
I'm
you're-
gonna ask both of you to refrain at this moment. Mr. Aquina, I read through your request for hearing, and I'm gonna deny the request. The case that you've cited deals with restitution. No restitution was ordered in this case. And as Mr. King stated, no funds were collected as part of that particular garnishment. So you're welcome to file additional cases, but as far as this case goes, I'm denying your request and your objection.
My request or my continuance?
I'm denying a request for the continuance, and I'm ruling that your objection is without merit, as no restitution was ever ordered in your case. Only court costs.
Right, that's true, Your Honor. But what's happening is Mr. King is going to try to charge me for his services, and he's going to try to charge me interest. So what I'm saying with the federal statute that you guys are in violation of is the county never notified me, telling me I had a debt to pay. If you don't notify me, and then Mr. King jumps in because he accumulated that debt so he could make a little more money himself. Those are considered unfair debt practices.
The court told you at the time of sentencing that you owed the money, Mr. Aquina. If you wish to file additional briefing on a new issue, you can do that, but this matter is dismissed.
All right, so I'll just send my notice of appeal and we'll go from there.
You have that right.
Thank you.
All right, if there's nothing further, we'll be in recess.